Got a refusal letter from Canadian immigration. It's upsetting, frustrating, and for many life-changing. But here is the truth. The refusal letter doesn't mean the end of the road. At Bellissimo Law Group, we help clients to turn refusals into approvals through the Immigration Appeal Division. So let's talk about what you can appeal and when, and how to fight for a second chance. Not every immigration refusal can be appealed. But if you're eligible, the Immigration Appeal Division, or IAD, may be the opportunity you need to set the record straight. Whether it's a sponsorship refusal or a removal order, understanding your options is the first step to fighting back. If you're a permanent resident or Canadian citizen who applied to sponsor your spouse, common law partner, parent, or child, and your application was refused, you might be able to appeal to the IAD. Or if you received a removal order and believe it was issued in error, or there are humanitarian reasons for you to stay in Canada, you might be able to appeal. Each case is unique and timelines matter. Usually you have only 30 days to start the appeal process. The IAD is a part of Immigration and Refugee Board of Canada, and it reviews cases in EU during its decision-making process. Unlike some courts, the IAD is not limited to the information that was before the previous decision maker. Rather, the IAD can consider new evidence, humanitarian compassionate factors, and how the decision may impact any child involved. Sponsorship appeals, often involving spouses or partners who are refused on genuineness of the marriage grounds. And parental sponsorship applications where sponsor did not meet the necessary income requirement. Removal order appeals for permanent residents ordered removed for criminality or misrepresentation. Residency obligation appeals for those who didn't meet their 730 days of physical presence in Canada over a 5-year period. Each of these requires detailed documentation and strategic legal argument. This is how typical appeal unfolds. Once the IAD accepts your notice of appeal, confirming that the appeal process has been initiated, you will receive the appeal record within 60 days, which will contain all the documents and information from your previous application or proceedings that are relevant to your appeal. From the date of the receipt of the appeal record, you will have 60 days to provide disclosure documents to the board, meaning all the documents that you will rely on in support of your appeal. After that, you might be invited to participate in the Alternative Dispute Resolution, ADR conference, an informal and faster way that does resolve many cases. The ADR is not generally offered in removal order appeals, but it is often offered in sponsorship appeals. If the case is not settled at ADR, you will go into the full appeal hearing where you and any witnesses you would like to call will have to testify. The IAD will then issue a decision, which can be to allow your appeal, to dismiss your appeal, or in cases of removal order appeals, it can stay the removal order for a period of time, meaning the final decision on your appeal will be made after this time had passed and you didn't get in any trouble with the law again. Strong appeals don't just argue, they prove, and you will need credible documents and testimony, thorough legal submissions, persuasive evidence of genuineness of your relationship to your spouse, or in removal order appeals, evidence of establishment in Canada, hardship in going back or losing your status in Canada, any child that might be affected by this decision, and any proof of rehabilitation efforts. At Bellissimo Law Group, we've seen how strong preparation can make all the difference. We take pride in building the appeals that are detailed, human, and rooted in the law. Appeals can take from a few months to over a year, but with early action, complete paperwork, professional guidance, you can avoid unnecessary delays and move forward with confidence. If your appeal is dismissed, it doesn't mean that all is lost. You may be able to challenge that refusal to the federal court or explore other options available to you depending on your circumstances. But the earlier you'll get the advice, the more options you'll have. Immigration appeals are complex, but you don't have to face them alone. At Bellissimo Law Group, we've handled thousands of cases at all levels, including at the Immigration Appeal Division and Federal Court. We don't just manage paperwork, we build compelling cases and fight for your future. Whether it's ADR or a full hearing, we bring clarity, compassion, and full understanding of the law. Has your immigration case been refused? You may have the right to appeal, but the time is short. Visit bellissimolawgroup.com for more information or book a consultation today. Our experienced team is here to guide you through the process every step of the way. And if this video helped you, don't forget to like, subscribe, and leave a comment below with your questions. Follow us on social media for the latest updates in Canadian immigration.